Hey, this is Mohammed Hasnan, and this video is regarding a very common yet important topic which has become the leading contributor to the problem of pendency in Indian judiciary. The topic, as you might have guessed or rather have seen from the thumbnail, is none other than dishonor of checks. According to report, there are over 33 lakhs pending cases relating to dishonor of checks in Indian courts. And these are the reasons that make understanding of the provisions relating to check dishonor essential for us. So without further ado, let's get straight to the topic. We all know check is a negotiable instrument. But what does negotiable instrument mean? Well, negotiable means transferable by delivery, and the word instrument means a written document by which a right is created in favor of some person. Thus, the term negotiable instrument literally means a written document transferable by delivery. Well, negotiable instruments are divided into two parts. The first is recognized by statute, that is, promissory notes, bills of exchange, and checks. And the second part is negotiable instrument recognized by usage or custom. Example of these are hundis, share warrants, dividend warrants. Well, the list of negotiable instrument is not a closed chapter actually. With the growth of commerce, new kinds of securities may claim recognition as negotiable instruments, and the court might allow it. Essentials of negotiable instruments. The first essential is it is easily transferable, as we all know. The second is the negotiable instrument must be in writing. It cannot be oral. The third is time of payment. The date of payment of the amount must be very specific in the negotiable instrument. Fourth one is the payee should be certain. The person to whom the payment is to be made, that is the beneficiary. That is, the name of the beneficiary should be clearly mentioned in the negotiable instrument. Now, from this slide onwards, we will discuss the negotiable instrument with respect to checks. We all know a check is a negotiable instrument payable on demand. There are three parties to a check. The first is drawer, the one who draws the check, that is, who signs the check. Second is drawee, the one who is directed to pay is drawee, and in the case of checks, the bank is always the drawee. The third one is payee. The payee is the person who receives the payment or who is the beneficiary of the check. Well, we all know the basics of check, but do we know what happens when a check gets dishonored, or in layman terms get bounced? If you don't know, no worries, we will discuss it right away. For starters, let's discuss reasons behind check bounce or dishonor of check. The first one being insufficient account balance. There is a misconception among some people that this is the only reason which comes under the ambit of section 138. Well, this is not the only reason covered under section 138 of NI Act, because on the contrary, the legislative intent of the whole act will get infructuous, as public would then be given free hand to use tactics to evade law. For example, the drawer can close the account or stop the payment before the payment of the check. And to prevent this from happening, the apex court has time and again come with clarifications. Therefore, the reasons under section 138 also includes upper limit set by the drawer, validity of the check, overwriting, damaged check, signature mismatch, mismatch of amounts or digits, and old stationery. Here, old stationery means when the drawer of the check uses or issues check from an old checkbook which has been discontinued by the bank and a notification regarding the same has been given by the bank. Now we'll discuss what is the procedure under section 138 of NI Act for dishonor of checks. Firstly, drawer issues check for discharge of a debt or other liability, and the debt should be legal. After this, the payee presents the check before the court within 3 months from the date on which it is drawn. Then, if the check gets dishonored, the drawee, that is the bank, returns the check along with a return memo, citing the reason for dishonor. Now the payee has to give a legal notice to the drawer within 30 days of receiving the return memo from the bank demanding the amount of check. And still, if the drawer doesn't comply, a complaint can be filed before the magistrate within 30 days after the expiry of the 15 days period from the date of receipt of legal notice by the drawer, that is, after 45 days. After this, evidences and arguments from both sides will be presented before the court. If the court finds the drawer guilty of the offence of cheque bounce, the court will pass a judgment of conviction against the drawer for the offence of cheque bounce or cheque dishonor. The next slide is about territorial jurisdiction of filing a complaint, or in layman terms we can say where can we file a complaint for cheque bounce. According to section 142 of Negotiable Instrument Act, the payee can file the complaint before the magistrate in any of the following places. The first is if the cheque is delivered for collection through an account, the branch of the bank where the payee or holder in due course, as the case may be, maintains the account. And second is if the cheque is presented by the payee or holder in due course in the branch of the bank where the drawer maintains the account and the court within whose local jurisdiction the said branch is situated. Now let's move on to the next slide. In the case Dalmia Cement Bharat Limited versus Galaxy Traders and Agencies Limited, the Apex Court observed that as far as checks are concerned, the NI Act provides for strict liability. Therefore, no mens rea has to be proved. In the next case, that is Ramavati Sharma versus Union of India, the Supreme Court provided a distinction between checks and other negotiable instruments like promissory note and bills of exchange, and said that both cannot be equated, as a promissory note simply creates liability, but by issuing a check, drawer desires that certain payment is to be made in favor of the holder. Therefore, the contention that Section 138 is unconstitutional because it provides punishment for only in cases of checks and not other negotiable instruments was rejected by the Supreme Court. Now, in this landmark judgment, the question before the Honorable Court is that what if the drawer didn't receive the demand notice? In such cases, the court held that the drawer can make the payment of the check amount within 15 days of receiving the summons. And if this happens, the complaint is liable to be rejected. Well, the next case, that is Dalma Cement Limited versus Galaxy Traders, deals with the question that when does the cause of action arises. In answer to this, the Supreme Court in its judgment said it is not the giving of the notice to the drawer but the receipt of the said notice by the drawer which arises cause of action, after which complaint can be filed before a magistrate, obviously after the 15 days limit. In the next slide, we will discuss Section 139 of the Negotiable Instrument Act, which provides for the presumption in favor of the holder that unless the contrary is proved, the holder has received the check of the nature as mentioned in Section 138 of the Negotiable Instrument Act, and it is on the accused to rebut the presumption on the basis of preponderance of probability. In this slide, we will discuss the nature of the trial, whether it is summary trial or summon trial. Well, normally, in cases under Section 138 of the Negotiable Instrument Act, summary procedure is followed, in which maximum imprisonment up to 1 year and fine up to 5,000 rupees can be imposed. But if it appears to the magistrate that the nature of the case is such that a sentence of imprisonment may exceed 1 year, then he may, by an order, can follow the summon trial or summon procedure. Well, lastly, we will discuss the punishment in cases of cheque dishonour. Under Section 138 of the Negotiable Instrument Act, the maximum imprisonment can be given is that of 2 years and fine that can extend to twice the amount of the cheque. And in some cases, both, that is the imprisonment and fine, both can be imposed. Thank you.